This is the claim. This is Stewart's copyrighted works. This is what the claim is about, copyright infringement. And we have the Terminator defendants that are named and the Matrix defendants that are named. And I went through this entire case, the exhibits and all the good stuff. And not just that case, I read through all of the cases because actually it had to be initially was filed and it had to be amended to add other charges. So the defendant's motion originally was to dismiss the claims. In the beginning, it didn't happen. But in an earlier case, because there was a lot of delay in responding and answering, and I'm gonna get more into that, why that's very important, very important. But instead of dismissing it, she was granted leave to amend her complaint to add to the complaint because it was copyright infringement, but RICO charges were also added to the civil infringement claim. The RICO offenses were for criminal copyright infringement alleged by mail fraud and wire fraud. And because, again, she did not prevail or provide sufficient evidence for the copyright infringement claim to show that, okay, this is sufficient amount of evidence to be tried in a court. I got enough evidence to say we're going to take it from filing a claim to being triable. This is a triable situation. She did not provide sufficient evidence to raise a triable issue, which means to be tried in court regarding the infringement of her copyright. So the RICO charge was also failed because they was using the same facts. So now that I gave you a backdrop on all of it, let's get into it and talk about some of the things that you can learn from. So when you have specific work, you have your IP, and IP is very important. Bring it up a lot in a lot of things I talk about. Intellectual property is what IP is. Your intellectual property consists of being protected federally through trademarks, through copyright, or through patent. If you're thinking of amazing ideals from your mind and transforming it and transmuting it into this real tangible world here, you're transmuting it in some type of way where you're taking that intellect and transforming it into some type of property. And the federal government will protect these assets at a higher level than what you would get from just producing it and bringing it into this world. If you federally protect it, you now have higher protections. As far as copyright, when you federally register a copyright for protection, because once you create it, like I said, you have a copyright. But when you federally register your copyright, it now invests in you specific exclusive rights that you can control. You can give permission for people to use some or all of those rights exclusively, non-exclusively, meaning you can give people permission to use those rights. Only they can use them, or they can be a part of different people that can use them, or you can give rights for some to use some and some to use others. Some of those rights that you have when you federally protect your copyright is the right to reproduce your own work, the right to distribute it, the right to create a derivative. And that is the question that we're dealing with right now, is the alleged claim that the Matrix and Terminators is a derivative of copyrighted work. You have a right to publicly display it. You have a right to do all these things, but you also have the right to stop others or permit others for doing it. And if they do it without your permission, then someone is violating your rights. If they reproduce, distribute, display, play, do all the things that's vested in you without your authorization, it becomes, and you federally protect it, it becomes a federal copyright infringement claim. But to win, if someone ever was to violate you, to prevail on that case, owners, athletes, creatives, you creating your copyright, if you want to protected at its highest level. Someone comes in, infringe upon it. You want to exercise that protection. You have to first prove you have valid ownership of that copyright. And then if you prove that, you have to then prove that the copying that you have an issue with is copying made of your original elements. What does that mean? We have so many colors, right? So many colors in this world, so many notes in music. We have so much of whatever. So we can't, no one person can claim all colors, all notes. We can't do that. What we can claim is how we have our original expression of how we use those notes, how we use colors, how we use words. We all, no one can claim right of ownership of specific words, but how we use those words, how those words connect us as a source of providing products or service can be protected. How we put together notes and create a unique sound can be protected. How we take our thoughts and write things down and string those thoughts together to make it an original expression can be protected. So when we talk about someone copying our work and it being protected, the government is going to protect those original expressions, the things that's very much is very unique to you. And so that's what has to be proven. Copying of original protected elements. When you get to that second element, so the first element is proving that you have a valid copyright, and you can definitely accomplish this and should accomplish this by federally registering it. Because if you federally register your copyright, automatically by default, you're presumed the owner of it. So you already prevailed in element one. If you federally protect it before there's an infringement, all you do is point to the record. That's mine. Now you prove you have a valid copyright. If you don't do that, there's a lot of other proving that you have to do. A lot of proving. But if you don't do that and someone infringes on what you say is yours, you cannot even make it through the court doors until you register a copyright. However, if you're registering after, they're not going to look at the record. You can't point to the record and now say, that's mine. If you try to register after someone infringes upon your stuff, you can't point to the record and say, see, I register, it's mine. They say, no. You registered after you said you was infringed upon. So you have to prove that you were even able to do that. So that's why it's good to register before there's an infringement. So you can prove valid copyright, a valid copyright. But now you have to prove copying. And that's where Ms. Stewart had a hiccup for several reasons. But the point is, she was able to prove ownership because, like I mentioned to you, in 83 and 84, she had a screenplay, then she had a full manuscript that she copyrighted called Third Eye. Third Eye is supposed to be, right, this story, this scientific futuristic story that is very familiar to the Terminator and Matrix. So she proved she had a federal copyrighted protection in her work and that she actually has a valid copyright by showing that registration before she claimed any type of infringement. But she could not prove copying. And if she could have proved copying, possibly she would have prevailed. I'm going to get into why and what you should do regarding the second element. Before I do that, I do want to, for some who's saying, like, who is Sophia? A lot of people should know, but I do want to share. Let's see. I'm going to share a snippet of an interview that she did. All right, here she goes. We'll play this. Put my headphones in.
This is the deal.
Mhm.
They didn't steal my work because it's copyrighted and I already owned it. That's why I owned the franchise, because it was just derivative. The movies derived from copyrighted source. So I copyrighted all the movies and took them and entered them into the court system. They sold the money. When you go and do a lawsuit, you're doing it because you're getting the damages. Damages are money.
Right.
That's the only thing they can steal is the money.
Right.
But it was a criminal act because what they did was violated copyrights. That's criminal copyright infringement. It's not
Mhm.
infringement. Infringement would be if you and I had a contract together and you didn't abide by the contract, and I would have to sue you for the money.
Mhm.
But criminal is when you take a copyrighted book, these all have ISBN numbers,
Mhm.
authored, and then you go and make a movie out of any of these books, and well, the feds are going to come and arrest you. The reason why they haven't gotten arrested is because they are commingled with law enforcement, senators, and politicians. They're paying to stay out of jail the same way Al Capone paid to stay out of jail, John
Mhm.
Gotti, Whitey Bulger, Bernie Madoff. They all paid to stay out of jail. That's why it caught up with them 20 or 30 years later. Bernie Madoff, he died.
Okay. I want to clear up something and share something with you. So let's back up a little bit from what was said. There is a possibility of filing two type of copyright infringement claims. The primarily the copyright infringement claim that will be filed is a civil matter. A private person, we're not the government, we're private individuals. A claim that is being filed by a private person is a civil matter, not a criminal matter. And when you file a copyright claim, you're not filing to prove damages. You're filing to prove infringement. Once you prove infringement, then we have a conversation about damages. Damages is not even a conversation unless there is an infringement. And if there is an infringement and you already registered your work before there was an infringement, then you can have statutory damages. I'm gonna get into that later between actual damages and profits and statutory damages. But I wanted to clarify that what was said in here, it's important for you as owners to know information to make elevated decisions. One, when you file a copyright infringement claim, you're not going to court to file for damages without filing for the infringement. You're filing because someone infringed upon you. And mind you, when you file a copyright claim, it doesn't necessarily have to be damages. You can file a copyright infringement claim and seek injunction, meaning you seek to stop someone from doing something. That's not even damages. You just say, I'm going here to stop everything that you have going on. That's what I want. But you are entitled to damages, and depending on how you entered the case, what damages may be available to you. So it's not true that you're filing a claim to seek damages and not infringement. It's the other way around. Secondly, I want to clarify that when someone makes a derivative of your work, that is an infringement of your copyrighted work. It's not okay. You can't say someone just made a derivative. They didn't steal my copyrighted work. They just made a derivative. Well, that is stealing from your copyrighted work. If you have copyrighted work, those rights that I told you are invested in you. When you federally protect that copyrighted work, those rights are the rights you control and that you give someone else permission to do or not do. And if they do it without your authorization, they are stealing from your copyrighted work. So I want to clarify that. That was misstated there. To give you a teachable moment, please understand, when you go to court, you're not going to court to just fight or prove damages. You have to prove a wrong. And then if damages attached to that wrong, there's a possibility you have to prove those damages you're asking for. Some damages you don't even have to prove. Like I said, that's statutory, or a jury will award those. So that is wrong. Secondly, infringement is doing something with your copyrighted work that you didn't give someone permission to do. That is stealing your copyrighted work. You don't have to steal the actual copyright from the Library of Congress, but you're stealing from that copyright. And then let me clarify this too, between criminal and civil. Like I said, most copyrighted claims are civil. It becomes criminal when the government is now involved. Remember I told you she attached RICO to the situation. It becomes criminal when the government is involved in what's actually going on. So the claim that I just showed you in the beginning of the segment, that was a civil claim of a copyright infringement. RICO was dismissed. And of course, this copyright was dismissed as well. And lastly, I want to point out, it was stated that, infringement would be if we enter into a contract and you don't fulfill that contract, you infringe. No, that's called a breach. Those are two different things. If I enter into a contract and you did not fulfill the terms of that contract, you have breached the contract, not infringed. But if I have rights that I didn't authorize for you to use, you have infringed upon my rights. So that was misstatements of a breakdown explanation. So for you owners, I want you to understand that. Which brings me to a gem to tell you, if you are sharing your copyrighted work with individuals, yes, you have your federal protection, but you may want to include language that creates a contract of expectations in you sharing this information. So now if that contract, those terms are violated, are breached, you have a breach of contract claim, not just a copyright claim. So that was incorrect. That was stated there, but that is Miss Sophia, and she's explaining that information. I can't speak to who's paid off, not paid off. Now, don't get me wrong. In these industries, it's wild. It is crazy. There's a lot of things that are done. Believe that. The justice system is not always just, and we know a lot of things happen. But strictly according to this case and reading this case, it's not that someone lost in these claims and then didn't get convicted or didn't get a judgment because they have money and paid people off. The actual holding of these claims is that they prevailed, not that they lost. And they're just not paying the penalty of them losing because because money's being exchanged. That's not the case. The court case clearly shows that they found for the defendants and not the plaintiff. So I just wanted to definitely plug in that nugget, that you understand, and hearing that, her saying it's just they didn't steal my copyright. They didn't infringe on it. It was just it was a criminal situation. One, it was civil. RICO could have been, yes, a criminal situation, but it was infringed upon by making a derivative. We don't want to speak of that like that's lightly. They only made a derivative. No, that's why there was this court case. So anyone who spins off of your copyrighted work, anyone who creates a work that derives from your work, that is an infringement.